Today's topic is Specific Relief Act, and the Specific Relief Act, as the name suggests, it is a relief which must be specific and is in the plaintiff is entitled for that specific relief. Second is that this particular statute is a branch of equity law, and there is already in the field the Contract Act, Transfer of Property Act. Both are in the field, but still a special statute is required or is made in respect of this specific relief. Another important, because being the equity branch, I will come to the what are the equitable principles are used in this branch. And in case of a contract, normally in a contract there are two kinds of remedies. One is that in case of a breach, what are the remedies? And in case of if there is going to be breach, what are the remedies to the person? So, Specific Relief Act is a branch which deals with both subjects. That in case of a breach of a contract, normal under the Contract Act, you know there is a damages. There are damages which are payable to by the defaulting party. However, Specific Relief Act has got something more and different, or in addition to the usual remedies of a damages or a reimbursement. That those remedies are specific performance. That is, the contract which is defaulted or which is breached is required to be specifically performed. So this is a new remedy which is introduced or is under this new act of Specific Relief Act. I told you that in case of a breach which is going to happen in future, there is a preventive relief which is contemplated and made available under this statute. So this statute roughly can be divided into two parts. Part number 1, that is sections 5 to 34, as regards the breach which is committed and what are the consequences of a breach of a contract. And part number 2 is in respect of the preventive remedy, that is from 37, 38 to 45. Those are the preventive relief. That is, there should not be a breach of a contract, or breach of a contract can be prevented. That is, we call it as a permanent injunction or permanent stay. So now, as regards the first part, the Specific Relief Act, as I told you, is having origin in equity jurisdiction. This codified law gives a platform or a basis for the statutory relief in case of a breach of a contract. Especially, we can take it a major affected area or major litigation area is of a contract of immovable property, agreement of sale of immovable property. There may be a contract or there are contracts which are agreements of sale of movable property. Specific enforcement of those contracts are contemplated under this statute. But in case of movable, unless that movable property, for example, it's a antique painting or some kind of antique thing, or which is a very rare or rarest thing which is movable, maybe movable, that also can be ordered to be specifically given, or duty can be imposed to perform specifically. So now, considering this, if we go to section 5 of the Specific Relief Act, because first sections are not that important or material. Now, section 5 is recovery of specific movable property, which is to be allowed under section 5 under the provisions of Civil Procedure Code. That is a normal provision It's a public policy that how you get your remedy. That remedy you can obtain from the civil court by following the civil court jurisdiction. The section 6 is important. Now section 6, which gives another principle a foundation or foothold, and the principle is, in case of ownership, possession is 9 points and title is another 1 point. So possession has got an utmost important, and that possession part of it needs to be protected or needs to be honored. So this is a very salutary provision under the Specific Relief Act, which gives a remedy to a person who is dispossessed from his settled possession. Then his remedy is to approach the court to claim back the possession. Mind well, the use of word is very careful. A person who is in settled possession is entitled to go to the court and seek a relief to obtain back his possession. I have not used the word about a dispute as to the title or a suit based on title, not at all required. So a person in possession or extreme case may be a trespasser for many years. He had come on the land or a property and living there for many years. In those situations, such a person is entitled to protect his possession, even qua the owners, against the owner. So even against the owner, such a person in possession can file a suit. If he is dispossessed illegally, without following due process of law, then in that case, he can claim back the possession from the court. Now, jurisdiction of the court under section 6 is very limited. The court has to see what? Number one, that whether he was in settled possession. Number two, whether he was dispossessed without following due process of law or forcibly dispossessed. Then that is the another aspect the court has to see. And then the relief will follow, which is give back him the possession first. Then you can claim the title or you can claim the possession based on your title. The person who is owner will say, I am the owner. How can I give him a possession? But the court will tell him that you give him possession first back. And if you have got a better title, if you are the owner of the property, file an appropriate proceeding to claim the possession by a regular suit for possession based on title. So this is a very salutary provision where the three important steps are that it must be filed within 6 months from the date of dispossession. Second, the possession of the person who goes to the court to claim back possession must be proved, must be established. Third, that he must have been forcibly, tacitly, fraudulently, surreptitiously dispossessed from that particular property. So these are the three parameters which are required to be followed in applying section 6. An important part of section 6 is that there is no appeal. There is no appeal against the order and judgment passed under section 6. There is only a revision which is maintainable in the High Court. This is again a very scarce remedy. Not the owner or any person who disposes such person against whom such remedy can be used. So these are a summary proceedings. These are by nature summary proceedings, and unsuccessful person, maybe he may be the person who is claiming possession, or the person who is unsuccessful may be the defendant. He wants to claim a possession on the basis of title, and his remedy is to file another litigation. So speedy remedy is given to the person in possession. The whole idea or intention is that protect the possession first. Protect the person's possession who is in possession legally or lawfully or settled possession. I will not say he had a title to be in possession. He may be a trespasser, he may be a surreptitiously entered into the property or overstayed his permission if there is no written contract. Even if after the termination of a tenancy or a license, the licensee's possession cannot be taken forcibly. The owner has to go to the court and prove that he is entitled for possession. So I will be giving few judgments, you can note it down. One is 1975, 4 SCC, page 518. That is Puran Singh. Second, which is offer judgment, is Rame Gowda versus M. Varadappa. Rame Gowda versus M. Varadappa. That is 2004, 1 SCC, page 769. And another one, Patna judgment was followed by Supreme Court. That only I will tell you. That is again 2004, 7 SCC, 515. Sudhir Jaggi versus Sunil Chaudhary. So section 6 is an important as regards the person who is illegally, unauthorizedly dispossessed from the property by a person who may be the owner of the property. So these are very far-reaching provisions in the Specific Relief Act which speak about the far-reaching consequences. There is an amendment in 2018 to this section 6 in a Specific Relief Act. It has added the words that such a person who is dispossessed or through whom he has been in possession. So this portion is added in 6. Any person, Chapude, or through whom he has been in possession is dispossessed without consent of immovable property otherwise than in due course of law. So these are protecting under the law possessory rights. Possessory right of the person are important and those rights are protected under section 6 of the Specific Relief Act. Now after section 6, if we go to the Specific Relief Act, the 7 and 8 I will not deal with, I will go to section 9. Section 9 is about the suits which are based on contract. What is his defense? So it is a general provision that his defenses which are available under the law of contract. Under the law of contract, if you remember, there are section 55 which says about delay. Principle in equity, because this is equity branch, where the defense in equity about the delay that a person who claims the specific performance has approached the court belatedly or not diligently. Equity code says delay defeats equity, or equity helps them who are diligent. So these are various parameters which are available to the defendant in such suits which are under the law of contract and also under the provisions of or under the principles of equitable law, equity law. Now section 9 त्यानंतर section 10 आहे. I will begin with section 10 with an amendment first. कारण amendment 2018 ला अशी आली आहे की सेक्शन 10 मध्ये स्पेसिफिक परफॉर्मन्स कुठल्या केसेस मध्ये दिला जातो असं त्याचे टायटल आहे. Cases in which the specific performance is granted. Now in this there is an amendment where the earlier provision was the court may grant the specific performance. Now this discretion to the court of may has been removed, and there the words are added shall. So discretionary nature of the relief in section 10, that once the court finds that there is an agreement, legal, valid, enforceable, a very little scope is that the court may grant a specific performance, court shall grant a specific performance. That is an amendment. Now, normal rule which you are opt knowing or everybody is accustomed to, standard of compensation is not available. It is also accepted principle that in respect of contract of sale or purchase of immovable property, the ascertainment of the damages is not possible. Value of the real estate or a property is difficult to be guessed or calculated or contemplated at the date of contract, and when actual performance, if not done and sought on a particular subsequent date, what would be the loss? So it is presumed that in case of a contract for sale of immovable property, the damages is not adequate. So there is no method or parameters for calculation of the damages. And second is other way around, you turn the coin other way. Paying a compensation to a person will not be an adequate relief. If I want to purchase my own house or a house in a particular village where I have gotten my memories or my childhood memories are attached there too, and I agree to purchase a house in a locality where I once used to live, and I enter into agreement with say Movable, and Movable agrees to sell that house to me say for 10 lakhs, and I pay him 1 lakh rupees. Subsequently turns around and say that I cannot perform this contract. You can take instead of 1 lakh rupees, 2 lakhs rupees back and forget about the agreement or a transaction. So this is the compensation to me is not adequate relief because it has got another dimensions or factors which are added to this particular property. So one is that in case of a movable property, there is no compensation which can be calculated. Secondly, there cannot be an adequate relief in the terms of compensation. This may happen in respect of movable property also. A particular painting is agreed to be sold, and particular painting of say Raja Ravi Verma of a particular style which I have agreed to purchase, you want to turn around and say that no, I cannot give you this painting. You can take your money, whatever you have paid. We have agreed at 5 lakhs. I am going to pay you 10 lakhs of rupees. So forget about this agreement of sale. So that will not be allowed to be done because adequate relief, adequate compensation will not give me that painting of a particular painter or a special thing which has got some value other than the except abstract painting itself. So in such situation, the explanation is given that in case of immovable property, I told you in the beginning, there is a explanation that breach of a contract to transfer immovable property cannot be adequately relieved by compensation in money. And the breach of transfer of movable property, जर ऑर्डिनरी आर्टिकल असेल, म्हणजे बाबा मला एखादी वस्तू विकायची, ते नॉर्मल प्रिंटेड पेंटिंग असेल, राजा रवी वर्माची केलेली बरीच पेंटिंग प्रिंट केलेली आहे, अशी प्रिंट केलेली पेंटिंग असतील तर दॅट विल बी ऑर्डिनरी. ओरिजिनल पेंटिंग विच इज पेंटेड बाय राजा रवी वर्मा विल बी अ separate or a very precious painting. But if it is a printed painting or maybe a scooter, maybe a bicycle, or these things which are there, which are commonly available, normally available in the market, which are in plenty, in those cases there cannot be a presumption that this cannot be adequately compensated. So it can be adequately compensated. Now this presumption of adequately जे आहे, फर्स्ट प्रिझम्पशन की इम्युएबल प्रॉपर्टीच्या बाबतीमध्ये इट इज अ प्रिझ्यूम दॅट ट्रान्सफर ऑफ इम्युएबल प्रॉपर्टी cannot be adequately compensated or contract cannot be relieved or cancelled. हे rebuttable आहे. This presumption is rebuttable presumption, and that for that you can rely on this judgment 2014 16 SCC 662 शंकर सिंग वर्सेस नरिंदर सिंग. The important part is that now it is not a conclusive presumption, but it is a rebuttable presumption, and it can be rebutted by giving other evidence or submitting an evidence before the court की सिमिलर प्लॉट एखाद्या लेआउट मधले पाडलेले आहेत 5,000 एक प्लॉट त्यातला मी ऍग्री केलेला आहे, आणि सिमिलर अजून 49 प्लॉट अजून अवेलेबल आहे 50 पैकी, and I offer him the another plot which is identically situated, same locality, same layout, same price, no change about even the area, dimensions, boundaries may be a little change on one side. So this can be shown that this kind of presumption is rebuttable. So this kind of presumptions under section 10 are rebuttable presumptions, and those rebuttal evidence, it may be laid by the party against whom the specific performance is claimed. Now then there is a section 11. Now whole emphasis of amending act of 2018 was, if you remember, I had told you that bankruptcy law was amended in 2018. This amendment to the Specific Relief Act has also come in 2018. 1st August or 14th August 2018, it has made applicable. Now, why this is done? This is done in order to see that specific performance do not remain delayed or lingered for long, number one. Number two, in case of such contracts, there should be a discretionary scope or confusion should be reduced or as far as possible removed. Because previously there was a wide discretion. Even if the contract is proved, even if my ready and willingness is proved, even if I have come to the court in time, the discretion of the court was so wide enough that court may refuse in spite of fulfillment of all these preliminary or basic conditions for awarding or granting specific performance. Therefore, the words or terminology may has been replaced invariably as shall. Section 11 is another such example that specific performance of the contract is a word was may in discretion of court. It is now shall in the discretion of court be enforced when the contract is to be done wholly or partly of a trust. In case of a trust or a trust buying a property, in those cases, normally the contract is specifically enforced. Now this takes me section 12. Section 12 हा सिमिलॅरिटी जर पाहिजे असेल तर सेक्शन 6 10 मिनिटं आहेत. मी 10 मिनिटात हा ओपन करतो. वी विल मीट टुमॉरो अगेन. नाउ सेक्शन 12 is where there is a contract. पहिलं उदाहरण सांगतो. 4 भावांनी कॉन्ट्रॅक्ट केलेला आहे. त्याच्यामध्ये 5वी बहीण आहे आणि 20 एकर जमीन मला देऊ केलेली आहे 4 भावांनी. 5वी बहिणीने सही केलेली नाही किंवा 5वी बहिणीला ते करार मान्य नाही. He doesn't want to give the land to me. Now whether I can enforce this kind of contract against 4 brothers, will my contract be valid in respect of 4/5 of the share, or if I cannot prove because 5th sister was not disclosed or did not become a party to the agreement, and subsequently sister says that I am also a co-owner of the property and I don't want to give the property to you. So what happens in these cases? Whether it is enforceable, whether I can get a specific performance. And second case is the reverse. Suppose we take a 20 acres of land, 4 sisters and 1 brother. For our example, we take that all the 5 have got an equal share. Now, the sisters have not signed the agreement. The brother has signed the agreement. Now, whether I am entitled to get a specific performance because brother represented that sisters also agree to sell you the property and I am selling you all 20 acres of land, and he accordingly executes an agreement, takes money from me for 20 lakhs, out of that he takes 5 lakhs and says that he will bring the consent of the sisters. No worry, even if they are co-sharers. So if tomorrow the sisters say that we don't want to give, this is our father's property, we want to keep it. So whether I am entitled to get a share of a brother by a suit in a suit of a specific performance, that is another question which will be there. And section 12 deals with such a situation. Section 12, the first part is about the first example. It is relatively easy. That out of 5, 4 brothers are ready, 1 sister is not ready, then specific performance can be granted of 4/5 of share. The remedy of such a purchaser will be to file a suit for partition if the property is not divided. So in case of the majority is agreeing to sell their major share and only a small portion has remained, then there will be a specific performance. Now, then in that case, court can order the so much of the contract to be performed, and for deficiency, आता भावाने मला सांगितलं 5वी बहीण पण येईल आणि सही करेल, काही काळजी करू नका, सगळी 20 एकर तुम्हाला मी सगळा पट्टा देणार आहे. तर compensation is payable to me. In such a situation, for unperformed or for committing a breach of the 1/5 share sale deed to be executed, I will be entitled for compensation from the forebrothers. So this will be a scenario number 1. The difficulty or the case law is developed in respect of scenario number 2. And there are various case laws on these points, even where the Supreme Court has differed about the views taken in earlier judgments, and subsequently Supreme Court has clarified or ratified a settled view. So the answer is not simple that whether I am entitled for specific performance where majority of the portion is not agreed to be sold to me, I will take it agreed. And where minor portion is only agreed to be sold, even though the agreement in composite is of entire land. So in such a situation, then where part to be left unperformed, if it forms a considerable part, and it may admit a compensation. म्हणजे not to be part which is considerable आहे, जो समजा 4 भावांची 16 एकर आहे, 16 एकर मला मिळणार नाहीये 4 बहिणींची, आणि त्याच्याबद्दल मला कॉम्पेन्सेशन मिळू शकेल, त्याच्याबद्दल मला कॉम्पेन्सेशन कॅल्क्युलेट करून मिळू शकेल. अशा परिस्थितीत काय करायचं, आणि अशी परिस्थिती विचारात घ्यावी लागेल की जर इथं कॉम्पेन्सेशन काढताच येत नाही, म्हणजे इट कॅनॉट बी कॉम्पेन्सेटेड इन टर्म्स ऑफ जो मेजर पोर्शन अनपरफॉर्म राहतोय, म्हणजे जे 16 एकर मला मिळणार नाही 4 बहिणींचे, त्या बाबतीमध्ये कॉम्पेन्सेशन मेजर करताच येत नाही. देन व्हॉट इज द रेमेडी? तर त्याच्यामध्ये रेमेडी मध्ये बर्डन इज अपॉन द प्लेंटिफ. जर समजा पहिला पार्ट मध्ये अनपरफॉर्म पार्ट जर मेजर असेल आणि कॉम्पेन्सेशन ऑफ मनी असेल, तर कोर्ट सेज that no, you are not entitled for specific performance. Second part मध्ये सुद्धा where the major portion is not agreed to be sold to me and minor portion remain is agreed, comes out that it is agreed to be sold, म्हणजे 4 एकर मला मिळणार आहे. Then also the section in the beginning says no, you are not entitled for specific performance. The next clause begins with the word but. तर बट करून कोर्टाचं ज्युरिडिक्शन याच्यामध्ये असं आहे, जर समजा वादीनी सांगितलं, इफ द प्लेंटिफ इज रेडी, फर्स्ट पार्ट इज ए बद्दल जर असेल, जेवढं कन्सिडरेशन मला द्यायचंय 20 लाख, त्याच्यापैकी जो पोर्शन मेजर होल आहे, 16 लाख, 4 बहिणींचं मला मिळत नाहीये, 16 लाख आहे, ते मी पे करायला तयार आहे. पेड और हॅज पेड फॉर होल ऑफ द कॉन्ट्रॅक्ट रिड्यूस बाय कन्सिडरेशन पार्ट, म्हणजे 16 लाख वजा करून उरलेल्याचे 4 लाख मी द्यायला तयार आहे. आय मेड अ मिस्टेक. इट इज अ 16 लाख वजा करून 20 पैकी मी 4 लाख द्यायला तयार आहे. अँड बी मध्ये, म्हणजे जिथं 4 बहिणी नाहीये म्हणतात आणि एक भाऊ फक्त अग्रीमेंट मधला माझ्याशी कॉन्ट्रॅक्ट केलेला आहे 4 एकरापुरता, तर मी संपूर्ण कॉन्ट्रॅक्टचं सगळे पैसे द्यायचे 20 लाख फॉर होल ऑफ द कॉन्ट्रॅक्ट विदाउट एनी अबेटमेंट. म्हणजे इन केस ऑफ अ बी, जर ऍडमिट करत नसेल कॉम्पेन्सेशन ऑफ मनी मध्ये, तर ज्याची रक्कम कॅल्क्युलेटच करता येत नाही, अशा बी केस मध्ये मी संपूर्ण पैसे द्यायला तयार असेल, जर संपूर्ण कॉन्ट्रॅक्टचे 20 लाख द्यायला तयार असेल तर, आणि त्याच्या व्यतिरिक्त आय शुड गिव्ह अवे, रिलिंक्विश अँड ऍक्सेप्ट दॅट आय डोंट वॉन्ट स्पेसिफिक परफॉर्मन्स किंवा कॉम्पेन्सेशन जे मला प्रतिवादीच्या चुकीमुळे मिळण्याचा अधिकार आहे. प्रतिवादींनी मला 20 एकर कबूल केलं द्यायचं, 20 एकर तो देऊ शकत नाही. 20 एकर पैकी त्याचा मेजर पोर्शन हा नाही म्हणतात, म्हणजे 4 बहिणी नाही म्हणतात, पण कॉम्पेन्सेशन त्याचं मनीमध्ये मोजता येतं, तरी देखील मी कॉम्पेन्सेशन घ्यायचं नाही म्हटलं पाहिजे. मी माझे हक्क संपूर्ण याच्यावरचे बाकीचे नाही परफॉर्म करता येणार नाही त्याबद्दलचे सोडले पाहिजे. म्हणजे 16 एकर वरचे हक्क सोडून दिले. दुसरा भाग असा